Good morning, Your Honors.
Thank you. Good morning.
Attorney David Mirsky for Isaac Wallace. Your Honors, first of all, I would like to make sure that you received my 16L letter, which I faxed and I sent by express mail regarding...
When did you send it?
I sent it the day before yesterday by express mail, but I faxed it also on the 6th.
I have not, at least, so.
We have.
You have that? Okay, thank you. That refers to Commonwealth versus Walden, and that I quoted the language that, and I think that's it's clear where that fits in. Your Honors, this is a self-defense case, really, where the trial counsel did not argue self-defense, and it's also, I would say, serious question whether the jury even had a chance to properly evaluate the evidence or the law, because of not knowing really the law that was in front of them without the issue of self-defense or provocation. The conduct has no explanation, and the definition of malice has no, is not going to be clear to the jury. I think malice, and I've heard in the appeals court, Justice Brown say that manslaughter perhaps should always be instructed, but without going into that, I would say the reason one might say that is because the instructions for manslaughter actually inform you what the malice really means in second-degree murder, and it tells the jury what they're supposed to look at. And here, what you have.
Excuse me, I just want to be clear. So, self-defense, as I understood the facts, the victim allegedly pulled his shirt up, and that was because he was reaching for a weapon?
Well, Your Honor,
and that triggered the self-defense?
Yes, Your Honor. I mean, that's the last act, but there's a series of other facts before that.
Date.
Yes.
But at the time of the shooting, they said they saw him pull his shirt up. Was a gun found by the police?
No,
Any
Your Honor.
weapons or anything like that?
No, Your Honor.
Okay.
What was the defense in this case?
The defense was that there was another shooter, another person in the car was the shooter.
Reed?
And Reed, and actually...
Are you saying that he should not have used the Reed defense and instead gone with self-defense?
No, Your Honor, what I'm saying
Should have done both.
Yes. Yes, Your
Isn't
Honor.
that a little hard to do?
Not in this case.
Somebody else shot him, but if I did, it was in self-defense?
Well, Your Honor, it doesn't have to be said that way, and that would be awkward and inartful, and probably would be ineffective on its face. But actually the trial counsel did try to use a provocation type of argument in saying that in her closing on page 35 of transcript volume 6, that Azan had more reason to think there might have been a gun in his pants because he was closer friends with Nixon, who's the person that the decedent had shot. And actually, which in itself shows a lack of understanding of the facts that had gone through the trial, because it was clear that the defendant was also a friend of Nixon, and that Nixon testified. They all knew about this.
Assuming
they all would
all
have known
those
this.
pieces are important and support your claim that there was some sufficient evidence, don't you also need some evidence of exercising a reasonable means of escape? I mean, isn't that tied to that?
Well, yes.
Is there any evidence of that?
Well, not that it's not that you have to exercise. You have to take an action. It's that, Your Honor, it's that you can't. I would say in this case there is none, because He's not the driver, and he doesn't know that, actually, there's testimony from the driver, Shavona Hughes, that she does not know the defendant, did not know his name, did not know him, and he's
You
not in a
need to be-
position to order her to drive off, or
Why?
because he doesn't know her. And actually, the evidence was that Azan Reed ordered her to drive off, and everyone yelled, "Go!" But I mean, that was after the shooting.
But aren't our facts that the door opens up of the van and then a shot comes out?
Yes.
So your position is that whenever somebody lifts their shirt to show that they don't have a weapon, that the lifting of the shirt is sufficient to trigger a self-defense instruction?
No, Your Honor, and that's not actually I haven't gone through the whole chain of facts that Chief Justice Ireland, I was pointing out to him before. First of all, that there's evidence that this decedent is a gang member, that he has taken, he has been shooting.
Previously shot, okay.
He has been shooting people in the park. He has been shooting people, one of whom is in the car. The van happens to be parked. It is parked. It's not a drive-by, as was suggested by the Commonwealth to the trial judge in the memorandum. It's not a drive-by. It's a parked car where the decedent, who is known to be this dangerous person, comes over, actually, and he's not called over. That's another fact, and we have to remember the standard that all facts are to be viewed in the light most favorable to the defendant, which is not what we usually do on appeal, but that's what is the standard here. And he was not called over. What the facts are that someone, and Azan Reed said it was the defendant, said, "There go Fritz." Okay, they said his name was mentioned, and he sparked up and he walked over and stuck his head in, and this is at nighttime, stuck his head into the van, and this is remember, a person in the dark stuck his head into the van, known to be a gang member. These are not, and the Commonwealth has said in its brief, there's no evidence that the defendant had any gang affiliation whatsoever, which there was innuendo about in the opening and closing, but there's no evidence, so there's no justification on that terms. There's no gang conflict here. This is people who are used to living with somebody who is a gang member roaming the streets. Shot one of them. He sticks his head into the car, into the van window, and sees something that made him back up. He backs up, okay, and then quickly, and then reaches, and then the door opens, and then.
Oh, no, wait a minute. He lifted his shirt
Right, he lifted his shirt. Right.
to show that he didn't have anything.
Well, he moved his hands to his waist, is what pulling his shirt means, and that's what it means
So
to me.
you would argue he was reaching for something under his shirt?
Yes,
You mean
Not
he
showing he didn't have a weapon, but actually reaching for a weapon?
yes.
But I'm sorry if I'm.
And there is testimony that
Did
it was
he-
probably, somebody said, actually in one of my issues about why didn't defense counsel use the statement that DeMarcus Kirkland said he looked in the window, he backed up, and lifted up his shirt like he was about to pull out a gun. Okay. Well, the trial judge in denying the motion said, well, that didn't even matter because that evidence already came in. He
Well, but didn't-
probably had a gun.
But didn't Kirkland say that he heard the shots first, and then he saw the victim? I forgot the victim's name, but he saw the victim, Fritz, reaching for something, and he thought it was probably a gun.
That's how Kirkland testified, but these people were all smoking marijuana. And
Well, what's the evidence to the contrary? What's the evidence that he reached for it beforehand?
Wasn't it that the statement that you think he should have gotten in
Yes.
says that he
Yes.
did it before?
Yes.
Isn't that what you're trying?
Yes, Your Honor.
But he didn't, he would not adopt that statement, would he?
Well, we didn't get a chance to actually confront him or even refresh his memory with this statement, which I think might have also gotten this in.
But didn't that statement also indicate that it was your client that did the shooting?
Your Honor, that witness had
And-
testified to that, and this evidence, as I said, it went to the state of mind of the shooter, whoever the shooter was.
Was there any evidence about what lifting the shirt meant? I mean, I guess I had envisioned it means lifting up the shirt to show you don't have a wetness, but you're saying it's lifting it enough to get your hands to your waist. So was there any evidence?
Your Honor, if you're lifting up to show that you don't have a weapon, it suggests that you might have a weapon, or you might be used to having a weapon there. It suggests that there could have been a weapon there.
Didn't Kirkland testify that your client was not the shooter?
I think he testified that he didn't know who the shooter was. He wasn't looking or something like that.
Okay, but in his earlier statement, the one that you say should have come in, or at least counsel should have tried to get it in, he indicated in that statement that your client was the shooter.
Your Honor, there was evidence. There was going to be evidence at trial and there was evidence on who was the shooter, and this fact that he might have been reaching for a gun and that's what it looked like, and he might be about to pull out a gun was relevant to the defense. Either what I'm saying it should have been, or what was actually tried by trial counsel, and she should have known this, and she should have had a better command of the facts.
I'm a
You're-
little confused about
don't
it.
follow
He
you.
did testify at trial that, okay, lifting up his shirt, on cross, right? What do you think he was about to do? Reach for something? I'm sorry? Reach for something. What do you think he was reaching for? I don't know, probably a gun. So that
In that
was
sense,
there.
it did come in, and I would agree to that. And my only point on difference from what the trial judge
Or an
said in
after.
his memo would be that it's much more striking to the jury. He looked like he was about to pull out a gun. To me, is more than probably a gun. But in terms of self-defense and in terms of whether that issue is made, I think it's there from probably a gun. But I would say it's much stronger from what could have come in. I would also like to discuss the failure to object to the mistake in the closing argument. Now, the trial judge in his memo tried to say, which I would say respectfully is not written as an analysis of what occurred in the facts of the case, but more of like an answer to the motion as like a closing argument would be. And we didn't have an opportunity to talk with the trial judge about any of the facts in this. We didn't have any kind of a hearing, which I think that even though it's in the discretion of the trial judge, the seriousness and the 33E should require at least some kind of discussion where we get to talk with the trial judge about what our arguments are and and to point out evidence. And also, this was quite a period of time passed between the trial and this motion, and that was not the defendant's fault.
But we have the evidence and we have the closing argument.
Yes,
And I gather Reed testified that, quote, everyone was saying, close quote, that they wanted the prints off. I gather there was evidence that the defendant was present at that time, and therefore isn't it a fair inference that Reed had said that everyone, including the defendant, was saying they wanted the prints off?
It would be a fair inference, and it is in the most legalistic terms, most the kind of terms that make people disapprove of lawyers, because if you look at the other evidence that the Commonwealth put in, that this man, Azan Reed, gave Shavona Hughes a bottle of Windex and said, "Wipe down the window." And this is the Commonwealth's witness. And Shavona Hughes identified from a photo the person who she said told her to wipe down the window was not the defendant.
So,
Okay.
your argument is that it is, in closing argument, a prosecutor can't focus on what one witness says when another witness says something different in a more persuasive way? Is that what you're saying?
No, Your Honor. What I'm saying is that when the whole issue before the jury, in part because we didn't have state of mind before this jury, when the whole issue is who did this, and when there's all kinds of consciousness of guilt evidence of Azan Reed having had a consciousness of guilt, having told this Shavona Hughes that she would be okay if she was quiet, having given her the Windex, having told her to wipe down the window, having been the one that actually did it with her, gave her the implements to do it, that this type of not just a misstatement, but saying, as I pointed out in my reply brief, that somehow the trial counsel, the defendant's counsel, had no right even to say this, because this, as saying, in a sense, I know this man, Azan Reed, is innocent. He has no right to say this whatsoever, and then to use a fact. To cover a fact that is a problem with the case, okay, which is that Azan Reed gave her the Windex, all right, it has a material effect on the jury. That's not all, placing before the jury just the facts and letting them decide. And it's something that, at minimum, and I know that the standard for reversal on that issue is lower when there's no objection, but at minimum, the lack of objection shows that the defendant's trial counsel wasn't even aware of what was going on here, because that was a thing that should have been called her right to her feet. I would like to ask you if there are any more questions that pertain to the first-degree murder charge, because there is a serious issue on the carrying firearm without a license. However, that's not as important to my client, but it is important to the Commonwealth and to this, to this country. But I don't want to go on to that unless you're ready to proceed with that.
However you choose to proceed.
All right. Well. May I have a moment?
You have 2 minutes. You use them however you want to.
Okay. The essence of the argument on the Second Amendment is that what you have is a licensing procedure that did not take into account the Second Amendment right, and it suggests that the legislature should hurry up and fix it.
What do we know about the licensing procedure in terms of evidence in this case? Do we have any information in the record that?
It's the statute, Your Honor.
It's the statute.
Yes, it's
And he has standing.
It's General Laws, Chapter 140, Section 131, which we're talking here about conviction under General Laws 269, Section 10A, and the crime is carrying a firearm without a license. And what I'm trying to point out is that this procedure under prior constitutional law that applied to the First Amendment, this can't be tolerated.
But he had a prior felony conviction, didn't he?
Your Honor, the point, first of all, that's not a fact in this case.
Well, I mean, if the issue had been raised, would it not arise that he has a prior felony conviction which under federal law would disqualify him from being in possession of a firearm?
If the issue were to arise, I would have investigated the validity of that any conviction, Your Honor. But that's not an issue for me. What's an issue here is that the procedure has to account for the right, the Second Amendment right. Massachusetts and this court did not acknowledge that the Second Amendment right applied or that it applies to this state until recently. At the time that, and I agree that a conviction could be a consideration. However, the licensing procedure should give an opportunity for the potential person seeking a license to seek to exercise their Second Amendment rights, and those are determined by the Supreme Court to be fundamental. Those are fundamental rights, and this licensing procedure just completely does not respect the Second Amendment rights. And also, by giving the discretion to the licensing authority, as a matter of law, it's abuse of discretion because this Commonwealth did not recognize the Second Amendment right that is now recognized at the time. And so any licensing authority would not be making their judgments on licensing considering the validity of the Second Amendment right with respect to whether this person was quote-unquote suitable to possess a firearm, which is the term in the statute. Thank you,
Thank
Your
you,
Honor.
counsel.
May it please the Court, Joseph Ditkoff for the Commonwealth of Massachusetts. With me is Ed Zabin. He's our Chief of Homicide and was the trial prosecutor in this case. Your Honors, the defense here that Attorney Joan Stanley pursued, and pursued carefully and diligently, was that Azon Reed, Ace, who was in the back row of the car, was the shooter and not her client. What was nice about this defense, from the perspective of the defense, was we wound up only having two witnesses who personally said, I saw Isaac Wallace fire that gun. And that was Ace himself and Shavona Hughes, who had the agreement. Now, we had some circumstantial evidence as well, witnesses like Nixon and Kirkland.
They're the people who said they saw a light-skinned African-American with long braids?
That was a Tia Britt who was not in the car. She was someone who was shopping. Mm-hmm. And she said that she saw in the car a light-skinned person with braids. And they all had braids except for DeMarcus Kirkland. Reed had the lightest skin of the people there, according to the detective, Detective Harris. So that defense certainly went with that evidence of a Tia Britt. Now, she didn't say that's the guy who I saw doing the shooting. The other evidence, of course, that we had was we had two other people who said that Isaac Wallace was the person closest to the door. But the only person that Joan Stanley really had to say is lying, besides the guy she says is the murderer, is Shavona Hughes, who we have the cooperation agreement with. That's why she chooses this defense. Self-defense, by contrast, she's got no way to show that he exercised all available reasonable opportunities to avoid combat. I mean, the door's closed, the window's tinted, but what he does is he slides open the door and fires. He could have...
Can you explain to me this shirt? I'm just confused as to where,
Absolutely.
apart from not exercising all reasonable means of avoiding it, where it comes from.
There isn't all that much testimony on it, so it'll be very easy to go through it. On page 215 of volume 3, Reed says, he backed away and pulled his shirt up and put his hands up, or something like that. In Cross, on page 12 of volume 14, he put his shirts and hands up. Then Hughes testifies on page 155 to 156 of volume 4, backed up and put his shirt up. I guess he was just showing he didn't want any problems. Now that's all the evidence of stuff that happened before the shooting. DeMarcus Kirkland testifies on direct on pages 114 to 115 of volume 4, When I looked, he was lifting up his shirt. In Cross, he goes into that on page 140 to 142 of volume 4 and says that it looked like he was, quote, reach for something. What? I have no idea, probably a gun. But he makes it clear that this happened after the shots. Now, Mr. Kirkland originally said, I saw the shooting, it was Isaac Wallace. This is what he told the police. By the time of trial, his story was, I was looking for my marijuana on the floor. I didn't see the shooting. I can't say who did the shooting. Of course, if he's saying that, he can't then go on and say that he saw what Isaac Wallace was doing at the time or before the shooting. So his testimony is very specific, despite the cross, that he saw this happen afterwards. Of course, what happens after the shooting can't be a basis for a self-defense instruction. Again, when you're choosing between your defenses, you can't have it both ways, even if you could get DeMarcus Kirkland to adopt his prior statement. And it seems very unlikely, since she really tried, when did this happen? And he's, no, it's afterwards. Even if you could get him to do that, if you make the jury think that DeMarcus Kirkland knows what happened before the shooting, well, then he saw the shooting. And he knows who did the shooting. And you stand a very big risk of changing your dynamic as a defense counsel from, I got the two cooperating witnesses, one of whom I say is the murderer. I just have to go after them, to suddenly add this person, DeMarcus Kirkland, the one person without braids, who can't possibly be a suspect, as someone that you then have to prove is lying. And that's a very dangerous thing to do. That's all the testimony, Justice Spotsford, about what the shirt is. Now, you get in Kirkland's earlier statement to the police that it looked like he was reaching for a gun. Well, I mean, that's pretty good, but all we have is he's lifting up his shirt to show he doesn't have any problems. And untucking your shirt is not a basis for shooting someone.
Does the record indicate that Kirkland was the only one without braids?
In the car, yes, Your Honor.
Okay.
I mean, obviously, of the males.
Yeah.
There's Shavona Hughes. I don't know what her hair situation.
Yeah,
no one cared about that.
Okay. All right.
She plainly was not the shooter. But yes, the record is clear about that. There was actually quite a bit of testimony about that. And the light skin thing was elicited 9 times in cross-examination by the defense counsel on Atia Britt. She really went after that as she was pursuing that defense. So for those reasons, this is a better defense. And on the evidence that was there was no basis for self-defense, both on the retreat, and there wasn't enough evidence of danger. He's lifting up his shirt. That's not enough, even if it's someone who at some time in that summer had been seen shooting in a park. It's not like Little, where the guy says, when he sees the defendant's gun, whatever, you want to bring weapons into it, we can bring guns and knives, and then comes after him noticeably high, saying, I'll F you up. I mean, he didn't use F, it was the real word. That's a much different situation. And even there, the testimony was that that looked like he was reaching for a handgun, which is something we don't have here. As far as Mr. Zabin's closing argument, I think the context is extremely important. In the defense, as I mentioned, defense has to go after Hughes and has to go after Reed. And the agreement the Commonwealth had with Hughes was that she would get probation. But what winds up happening is the charges of accessory after the fact to murder are just dropped. Defense counsel mentions that in her open, on page 21, volume 3, in her cross-examination of Shavona Hughes. The first 4 questions are all about the dropping of the charges. That's page 190 of volume 4. In the recross, again, the first 4 questions, all about the dropping of the charges in page 208 of volume 4. And of course, in her close, again, mentioning the dropping of the charges, page 25 of volume 6. So this was definitely something that the defense counsel was going after and something Mr. Zabin had to address. And that was the context in which he talks about the wiping off of the car. Why are the charges dropped against Shavona Hughes? And he says, this is a technical accessory after, legally sustainable, but technical, because here she is, someone in her car just shot someone without provocation, and then she's told to wipe down the car by him, she's going to do it. It wouldn't be nearly as mitigating, the fact that also, Azan Reed, who she didn't just see shoot someone, was telling her to do that. At no point does Mr. Zabin use this, say Azan Reed didn't say that, or use this as conscious of guilt in the context of this is why it's Wallace instead of Reed. It was solely to explain, and I've put the entire close in my appendix, solely to explain why the charges are dropped. And in that context, you'll see when you read the whole close, this was not used in any way that was misleading or improper. I would like, despite the lateness of the hour, to just briefly address the Second Amendment issue.
Just let me ask one thing about
Of
that.
course.
Do you agree that even if the prosecutor had not explained the dropping of the charges, that he was entitled to argue that that the defendant did request that the fingerprints be cleaned off the van?
Oh, absolutely. And that was the testimony of Azan Reed, that the defendant, if he had said the defendant only, or just the defendant, not Azan Reed, that would be a different situation. Azan Reed never also says that I, too, asked Shavona Reed to take the fingerprints out.
The testimony was the defendant or everybody? I'm sorry.
Everybody, but the defendant was absolutely plainly there at the time. The
So what you're
testimony
saying
was.
is he didn't say the defendant, it was a general, everybody was doing it, and from there you extrapolate the defendant.
Yes, the defendant is part of the everyone who was there at the time. So yes, I think he could have argued that as long as he didn't, as he did not, say, and Azan Reed didn't. That would have been misleading. There was no evidence from which you could get both this instruction and Azan Reed not instructing. So the final thing I just wanted to say about the Second Amendment is that I think when the dust clears, the people who will have successful Second Amendment challenges will be the people who apply for licenses and then challenge the denial of their licenses. And it may well be, as my brother argues, that some of our chiefs of police will need to change some of what they're doing. But this kind of challenge is like saying there's something wrong with the DMV, so instead of going for a license and challenging that, I'm just going to drive without a license, wait till I get an accident, and then say, oh, well, there was a problem with how the eye tests are done. I mean, that's the problem here. And, the federal cases, the feds don't have a personal possession licensing scheme. They have certain things that are just categorically barred, so they have to defend it as a substantive matter. But what ultimately we're doing is defending a licensing system, and people who don't try to get licenses and have that explanation, I think aren't going to ultimately have a case in challenging our licensing system. And if there are no further questions.
All right, thank you, Counsel.
Thank you, Your Honors.
All rise. Hear ye, the